Creator of all that is, it is in gratitude that we stand. It is in our standing that we feel your hand. Our size is small, for we are one, but we are large, for we are not alone. Our heartbeats prove tirelessly of your love, and so it is.
Thank you, Charlie.
My pleasure always. Hello, my name is Charlie White. I'm with the Oregon Statewide Jural Assembly. We took a trip to Salem, 6 of us in our assembly and our court, and met with Bill Burgess there in the office of Marion County Clerk. So I'm going to read a letter that is a response or a wrap up and a request, demand, suggestion, call it what you will, to Bill Burgess. And of course, his counsel was called in because they always refer to legal. So this is a letter to Bill Burgess, and there was a courtesy copy to his attorney for the county. Greetings, Bill. 6 members of our Article 3, Amendment 7 Civilian Common Law Court of Record met with you and your counsel, John Pettifer, in your office Wednesday, October 2nd, 2024. We appreciate your considerable time and attention listening to us and to our position. I have included a link to the portion of the Marion County, quote, official recording references listed alphabetically with corresponding Oregon Revised Statutes and/or other authority, end quote, a copy of which you could not find at the time, that we felt appropriate for filing our notice of intention to commence a proceeding. I have scanned pertinent pages of the one you gave us a copy of approximately a year ago. The constitutional references and history we cited in your presence prove our authenticity and authority over the current de facto color of law admiralty system that includes every incorporated, commercialized against the people entity and station of government over the people, not on behalf of the people, all of us. You refused to accept the veracity of our well-researched, also known as known and stated and sworn position as a lawful one Supreme Court, Article 3, with Amendment 7 in suits that more than $20 in common law without appeal in fact. That is you, de facto. Denial that Article 1, Section 1 of Oregon's Constitution is unacceptable to those of us who have learned that the Washington, D.C. government is not serving the people, as we have all been led to believe, but that you serve and enforce the long-standing misperception by continuing receipt of your paycheck and not finding a way to truly represent the informed, diligent, and committed people who stood in front of you last Wednesday. Since 1859, the people in our nation have allowed the con and deception to slowly and insidiously infiltrate every element of our governance, who either don't, can't, or won't take the time to question the history and nature of the authority they have given themselves over to. And now that very same increasingly awakening public is realizing our power, our self-responsibility, and our self-governance, we are returning to a de jure Article 4, Section 4, a return to a common law, constitutional Republican form of government this year, 2024. We are that. We are de jure and are the harbingers of a massive movement that will soon displace you in your current position of authority as the minions and gatekeepers for the de facto color of law corporations. Here's the choice. All that said, you, Bill, signed our document, Notice of Intention to initiate a proceeding as, quote, read and received. And that's appreciated. This is on you both, as men within your corporate structure, to find in your purview your recording references and de facto statutes, not law as guaranteed in our original, the United States of America's Constitution, circa 1859, a lawful place for our court and our Article 1, Section 1 assembly, that is the social compact, to register our land, soil, dirt jurisdiction, which entails Article 7, original, 1910, not Article 7 amended. If you cannot find or facilitate a way for the people on Oregon to be capable of registering into your registration system of land, property, lots, and plots that does not involve the monetary, then you will have proven there is no place for the people in your for-profit on the people corporation entities. You will have then proven our point as to an impregnable wall of governance that is neither willing nor capable of more than seeing the people as a source of income for your handlers. Once you do this homework, you will find there are no lawful courts on Oregon but our court. When our findings break through your misunderstanding of the true history of our nation, kindly notify us as to when we can submit our instrument that Oregon's dirt is the jurisdiction of, by, and for the people. Thank you for your time. I am submitting this letter on behalf of the de jure provisional government on Oregon, OSJA, and our website is orsja.org. Thank you.
Thank you, Charlie.
My pleasure. My pleasure. This is an open letter to the Oregon sheriffs and deputies. You, the sheriffs, along with your deputies, are the frontline facilitators of the people's unalienable rights to live our lives lawfully and in peace, safety, and happiness. Numerous requests, suggestions, and demands have been mailed and emailed, and in discussions face to face over recent months and years by the people on Oregon who have joined a social compact to remedy the problems governance has created and imposes on us unlawfully. Statutes and ordinances are not constitutional laws, nor should anyone breaking those de facto color of law laws be considered a criminal. We follow the Oregon Constitution and the United States of America's Constitution, both circa 1859. Our bona fides are in order, and we acknowledge and abide by the laws of nature and of nature's God. We expect the same of you and your deputies. Here's a short clip as an example.
Our God-given rights. And it says when government becomes destructive to these ends, meaning when they go above and beyond trying to secure our liberties and trying to take them, it's the right of the people to alter or abolish that government, either by voting or ultimately, God forbid, to use our Second Amendment rights to protect ourselves from tyranny. And I'm just asking all of y'all to unanimously join our sister counties of Wilkes, Surrey, Stokes, Lincoln, and Cherokee and get on board with this thing and publicly demonstrate to us that you're willing to uphold and honor the same oath I took when I put my hand on God's word and held my other hand up to him and swore that I'd give my life to defend that Constitution. And I'm not trying to be disrespectful, but regardless of what y'all do or don't do, I'm not going to enforce an unconstitutional law. I'm going to
Our jury pool and our Article 3, Amendment 7, Common Law Civilian Court of Record knows that we are men and women with our progeny on the land and soil, aka dirt, on Oregon, not some dead to the corporation entities as we are treated. Our unalienable rights are increasingly trammeled by the heavy boot of authority that has taken every facet of our common law and made it color of law. Sheriffs are supposed to be the first line of support for the people, for us. Yet in 6 of our court's 10 ballot issues put before our grand jury, our court now finds it necessary to honor the resulting true bills with an arraignment and a petite trial holding all 36 sheriffs, along with the DPSST, accountable for failing to acknowledge the seriousness of their failure in providing a proper oath to the proper constitutions circa 1859 with God included. Then you would see that the 6 issues are serious and solvable without the unnecessary belligerence and or harm that continues. Were this to occur, that our demands be acknowledged and that all of you willingly work with us for remedy, there would be a hospitable and mutually supportive relationship that would replace the current hostility and danger, even harm, done to your fellow Oregonians. You, the sheriffs, along with your deputies, are the frontline facilitators of the people's lawful, unalienable rights to live our lives in peace, safety, and happiness. Thank you.
Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. I want to read to you our notice of intention to initiate a proceeding. We filed this with the Marion County Recorder. The governance on the state of Oregon, aka all caps state of Oregon, and its counties, all subsidiaries of the now defunct United States, Inc., have chosen to acquiesce to our Article 3, Amendment 7 Common Law Civilian Court of Record multiple times since the year 2021. By sheer persistence of our Article 1, Section 1 Social Compact and the volumes of communication, we are the established provisional government on Oregon. We are the people on the land and soil, de jure, jurisdiction, wherein our rightful claim to the dirt on Oregon is changed from Article 7 amended to Article 7 original, and therefore to the people on Oregon as determined by our lawful common law civilian court of record. there is a preponderance of evidence showing overreach, the actual harm to Oregonians by the existing incorporated and illegitimate de facto governing entities, sheriff, legislatures, the judiciary, elected and appointed officials, all without proper oaths to the proper Constitution. The United States of America's apostrophe S Constitution circa 1859 and Oregon's apostrophe S Constitution 1859. And with the laws of nature and nature's God included. This is a court order. Our court will be proceeding with a grand jury in the anticipation of a true bill leading to a petite jury trial, reclaiming our lawful authority over the land, our children, and the people's inherent right over our affairs, civically, spiritually, judicially, commercially, and personally. With full faith and credit, governing law is established in this document at this time, and it is not the Declaration of Independence, but the unanimous Declaration of the 13 United States of America. They renamed it, and they lied from the very beginning. Not the document, but the people that have been doing the de facto fraud upon us on Oregon since November 8th, 1910. So we know what governing law is, and we wrote it down and gave it to them, and they have it. And now everybody here has it. The governing documents that they are using, the constitutions, are not legitimate. They're bogus. We have to be a de facto annihilator. We have to remove the de facto from the de jure. And we're doing that. And we're doing it with the sheriffs. And we're doing it October 21st, Monday, 10 o'clock in front of the courthouse on Marion County. And I yield.
My pleasure. All of us on de jure Oregon, without the de facto state of Oregon, within the United States of America. That's all of us. Where is the repository for the documents we are seeking? The original statehood documents making Oregon the 33rd state among the several states of the United States of America's constitutions of 1859 and Oregon, being admitted to the Confederation and Perpetual Union, dated February 14, 1859 Constitution. That one and nothing else. The duplicate copy of the same documents are being held by the de facto United States of Washington District of Columbia, Inc., in what is left of their 10 square mile. All of us on Oregon who are seeking remedy must deal with the de facto until it is gone. No one in our current governance system invented it or even knew it existed. That was until they learned of the deception. Now, even now, there is no excuse of ignorance among our sheriffs and their deputies. We've told them many times. The Oregon Constitution of 1857 is what allegedly went to the United States Congress, located at Washington District of Columbia, a 10-mile square on the Potomac River between Maryland and Virginia. The minimum documentation is what Matthew Deedy wrote about in his 2 books on Oregon published by Oregon's Press. What came back is what is important. Matthew was very explicit in what he saw and reported on. Verification of what is claimed is reasonable in all law forms. Oregon, the state, is de jure, and the state of Oregon is a de facto subdivision of the U.S. UN New World Order, and not as written in Article 4, Section 4. And I quote, "The United States shall guarantee to every state in this union a republican form of government, whether it has become a color of law oligarchy out of Salem or not." Our court has been denied twice by two Deputy Secretary of State for Oregon. Once by Bar Attorney Richard Vial, Deputy Secretary of State, and by Stephanie Clark, Archives Supervisor. They refused our court of four a viewing in 2017 after specifically agreeing to an appointment. The second time, Cheryl Myers, the current Deputy Secretary of State, also refused. Cheryl also refused to correct her oath. This information and more has been presented to Counsel P.K. Runkles and A.G. Ellen Rosenblum. That is misprision of felony. It is the paradox of Amendment 8, quote, Anti-Titles of Nobility Act, end quote, that should be in our statehood documents and is not. It needs to be pointed out how this juxtaposes with Article 7 amended. It is clearly there and should not be. This is signed, sealed, stamped, witnessed, proof of service, and published at www.orsja.org. Thank you. So my name is Charlie White. I'm with the Oregon Statewide Jural Assembly. We've been working assiduously on getting proper oaths from our public employees, public officials. I don't call them public servants because they seem to be serving a different jurisdiction than the one we want the oath for. So this is a letter to Cheryl Myers, who is the Deputy Secretary of State. We have a lot of correspondence that we send to her. This is one more very personal letter, not a document per se, but one that we feel is really important for her to address. Regarding a direct communication without court record to Cheryl, Deputy Secretary of State, from Charlie, Deputy Court Clerk and Director for the Provisional de jure Government on Oregon. Greetings, Cheryl. I speak for all of us on Oregon in our de jure jurisdiction who request liaison with you. As a woman and in your capacity as Deputy Secretary of State with additional responsibilities to Oregon tribes. Here's the situation as recorded as fact on www.orsja.org. Article 7 amended fails in legality and legitimacy. So does your oath and every known oath by all the de facto governance, including all 36 sheriffs and their deputies. There is not a proper oath to the proper constitutions, circa 1859, with the laws of nature and of nature's God included. This is indisputable fact. Our de jure constitutions, circa 1859, and even the United States Constitution you took an oath to, with its unlawful Oregon revised statutes, require you to abide by governing law. Further, you make your claims on your presentation card and on the internet that you are accepted by the tribes on Oregon. We find that interesting. They are on the land soil jurisdiction, as are we, the Oregon Statewide Jural Assembly. We are the de jure provisional government on Oregon, Article 1, Section 1. We know we share original jurisdiction with them. What is on the horizon nationally is what we have been doing here locally on Oregon, restoring our republic. I know you receive our letters and emails, as does P.K. Runkles Pearson. P.K. is fettered de facto color of law counsel. Whether she is registered or unregistered, she is a foreign agent, FARA. She is an Oregon State Bar attorney with an oath to a foreign state. This is indisputable fact as well. We will be on Salem Monday, October 21st, 2024, in the afternoon. You are petitioned for redress of grievance from our Article 3, Amendment 7 Civilian Common Law Court of Record, who will have at least 4 members of our court in attendance. We will visit your office on that day to meet with you, preferably, or your representative, where we look forward to having a meaningful conversation. Respectfully, Charlie White, Deputy Court Clerk for the Provisional de jure Government on Oregon, per the United States of America's Constitution, circa 1859. Thank you.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car, and he's got both his hands up.
And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.